we started. So once again, hello, good afternoon. This is Ruth Cusick, and I'm a senior supervising attorney in the statewide education rights project of Public Counsel. We appreciate all of you for joining us today on this webinar focused on charter school transparency and accountability. You can see from this first slide that this webinar is put together in partnership our statewide team with public advocates, the ACLU of Southern California, and the East Bay Community Law Center. I will be introducing all of our presenters in a few minutes, and then they will be going through their various sections. So thank you again for joining us today, and we will get started. So the first thing we will do is go over our agenda and some setting context information. And as I said, go over the presenters, and then we'll be going through three main sections around new legal responsibilities around transparency, accountability, and due process. So our agenda today will be an orientation to a new law on transparency and accountability, SB 126, and then we will also be reviewing implementation of AB 1360. We previously did a webinar when this law first came into effect, and we'll now be reviewing some issues around implementation, and then we will be talking about what all of you can do in your various roles. So today's presenter on the webinar, since we did not do a video presentation connected, we thought we should at least share our photos with you. So again, I'm Ruth Cusick from Public Counsel. Angelica Honko from Public Advocates will be presenting on SB 126, and Oscar Lopez from East Bay Community Law Center, and Victor Liang from the ACLU of Southern California will be presenting on implementation of AB 1360. All right, so just to quickly know who is joining us today, we're going to do a poll to find out who is with us. Okay, now that functionality is not showing up for me, so I think I'm going to let that go and not try to troubleshoot it with our team member. Apologies for that, you all. There's all of these special features. Oh, sure, thank you. If you want, we would love for you to go ahead and enter into the chat box, whether you're joining us as someone who in their career is working as a charter school authorizer, whether they're staff in a district office or on a school board, whether you're a charter school operator on the board of a charter school or a school site leader, whether you're a teacher or other school staff member at a charter school, whether you're an educator, administrator, teacher, or other staff member at a traditional public school, or if you're a community member interested in these issues. Those are obviously not all of the stakeholders associated with this work. If you're a parent, other roles, feel free to let us know. Also, apologies if I'm trying to see that there might be some issues. Okay, so it looks like some folks are hearing me well. I'm going to try to just be really good to be very consistent by my microphone. Apologies when you're doing the facilitation and trying to read the chat. It can be a little challenging, so I hope folks will be okay, and thanks for the offer that folks made. You can always dial in on your phone, and that might improve your quality. So apologies that our normal poll functionality didn't work today, but please type in the chat to let us know where you're joining us from today. Thank you. Okay. So quick, we just wanted to set some context before we get into the substance of our presentation, to be very clear in the education and outreach work that we are doing, that legally we all understand that charter schools are part of California's public education system. Our team at Public Counsel has done several community education trainings helping parents understand their different school options, and we have heard over and over from parents core misunderstandings, their perception that charter schools are like private schools, that they are not public schools. So we're really excited for the opportunity today with all of you to discuss important updates around transparency and accountability and fundamental student and family rights in charter schools, and keeping with this fundamental legal fact that charter schools are part of California's public education system. Now, what I'm going to do is just change the presenter, because Angelica will be reviewing all of the information about SB 126. So you'll just get a message as she accepts the switch. So thank you for bearing with us in transition, and we'll soon be hearing from Angelica. Thank you. Go ahead, Angelica.
Hi, everyone. So again, this is Angelica Honko, Deputy Managing Attorney with Public Advocates. And over the years, we've done a lot of work around accountability and transparency across traditional public schools and also with respect to charter schools. So many may have heard that in early March, Governor Newsom signed into law SB 126, one of the first new laws of his administration. And let me move this forward. So the focus of SB 126 is really to clarify that charter schools are subject to the same transparency, open meeting, and conflict of interest laws as school districts and as other public entities. So while charter schools are given more autonomy than district public schools, they control public funds and they exist for the benefit of educating students. And so they also and their boards, their governing boards, do also have to comply with the same types of sunshine laws that apply to public school boards. This law actually codifies what many have already thought to be true, and many charter schools had already been complying with these laws. Some had already had that written into their charters with their authorizers, and the state attorney general actually issued an advisory opinion last December that had been pending for quite some time, but stating definitively that these laws do apply to charter schools. So SB 126 basically codifies that. And the thinking behind it is that the public has a right to expect transparency from charter schools because they are licensed and paid by the state to participate in the core function of educating California's children. So even though charter schools many operate as nonprofits, they do have to comply with other laws that apply to public entities. So the main three areas of focus covered by SB 126 include requiring charter schools and the charter management organizations where a charter school might be, the charter management organization might oversee multiple schools to comply with these same laws with regard to open meetings, public records disclosures, and also conflicts of interest. And these will be codified in the Education Code in the Charter School Act at 47604.1. And I just want to point out, because Ruth wanted to say that if folks have clarifying questions, you can definitely type them into the chat. Our plan right now is to, in the interest of time, hold questions till the end. But please feel free to type questions along, and we'll be following along and try to get to them. Hopefully, we'll have enough time to get to as many as possible. Just some context, and I think many are familiar, that charter schools receive approximately $3.4 billion in public funds through the local control funding formula and serve about 10% of our state students. So they are a big piece of the public education system. And so it is important to ensure that charter schools are acting as good stewards of the public funds they receive and service those students. And so that's why that was kind of the basic intent, I think, behind SB 126. So I'm going to go in through each of these three areas in just the very basics. So with respect to open meetings, the law that really governs is the Brown Act for most schools, but where the Bagley-Keene Act governs state entities. So where a charter school is authorized by the state, it would be Bagley-Keene. The requirements are virtually the same. First, all meetings of government bodies must be fully open and accessible to the public. So there are a clear set of requirements under these acts about how meetings should be run. These will be familiar for those who might be on who are authorizers or school board members or who participate in those meetings. They have to do with posting notice 72 hours in advance. And now that posting requirement is online, it's having very clear agendas about what you're talking about, what will be discussed. Boards must deliberate, discuss, and act on the public's business openly. So in addition to having those agendas, the meetings must be limited to the action items on the agenda so that people have notice about what's going to be discussed. And exceptions to the rule of openness are few and narrowly construed. So that means, you know, even while closed session is permissible and it is possible to talk about some matters in private from the public, in general, most things should be discussed in public, and there are very few exceptions to that, mostly having to do with privacy, employee or student privacy rights. There are also a set of rules around what the public's rights to participate, attend, and comment at meetings. The public has a right to criticize, free from retaliation. A member of the public can comment anonymously, not have to submit a speaker card. I'm not going to go through at length these particular requirements under the Brown Act, but only to say the overall thrust is really about how do we set up a system, how do we have meetings where the public's business is being done in public. And there's also a whole kind of set of rules about what constitutes a meeting as well. So just to talk a little bit about open meetings and kind of why this is important. That intent is stated in the law in the Brown Act. The public commissions, boards, and councils, and the other public agencies in the state exist to aid in the conduct of the people's business. It is in the intent of the law that their actions be taken openly and that their deliberations be conducted openly. So if you are a charter school board member, most often in nonprofit boards, you might not be thinking that you're doing the people's business. For a charter school, you are actually conducting public business, and so your deliberations, especially deliberations of a majority of your board, must take place in public in a meeting. And I see there's a question about how do things get put onto the agenda. We can answer. We can answer that. And there was a correction that even schools authorized by the state board, the Brown Act applies, so we can clarify that too. So, but yeah, items get put on the agenda. Even the public can put in, members of the public can even ask to have an item put onto the agenda. And I think that would be kind of governed by the bylaws of that board. Let's see. So I just want to say a quick disclaimer because this is not a focused training about the Brown Act, and the requirements of the Brown Act are extremely detailed and complex. So the purpose of this is more to alert you to the need to be paying attention now, making sure that your charter schools are providing the opportunity to have open meetings and does not constitute legal advice. As a lawyer, I want to tell you that. And if you are a charter school operator or a board member, you really should be consulting with legal counsel to make sure that you are kind of in compliance on that front. So in addition to kind of the basic provisions of the Brown Act, there are specific provisions in SB 126 about meeting locations and operations that maybe are specific to the way that some charter schools operate. So in particular, the charter school governing body must meet in the county where the school is located. And then for schools, for operators where there are multiple schools that might be across multiple counties, or an operator that might not have a facility, then they should be meeting in the county with the highest student enrollment. So this is really about, again, having the people's business conducted in view of the public, and particularly in view of those who are most impacted. So there's the high bias towards meeting where your student enrollment is, to really make the meeting accessible to those being impacted by the decision making. There's also now a requirement to have audio or video recordings of meetings and to post those on your school website. And then to have a two-way teleconference line where you're having that meeting not at the school site where there might be multiple school sites or perhaps resource centers, then to have two-way teleconference lines set up so that people at that site might be able to follow along with the meeting. So these are all kind of new provisions that come into place with SB 126. The next big piece of SB 126 is on public records, another piece of sunshine law. And this is really requiring public agencies to make their records available, information available to the public. The animating principle behind this is that access to information concerning the conduct of the people's business is a fundamental and necessary right of every person in this state. So the California Public Records Act, many charter schools are complying with that already, but some do not. And I just wanted to see if either Ruth or Oscar, if you want to chime in with your experience with this.
Yes, this is Ruth Cusick again from Public Counsel. So in connection to some systemic monitoring work and in connection to casework on behalf of families to understand discipline practices or other data points, we have had serious challenges with charter schools responding to the initial response, the 10-day requirement, serious delays in getting a response, and then kind of following delays in producing related documents and the scope of those documents. So there have been some significant challenges around disclosure. So we're excited about this important step to make sure that this can now be followed by our charter schools and operators.
Yeah, so and the Brown Act can be a basis, like non-compliance with the Brown Act can lead to a complaint and could lead to litigation. Oh, sorry, with the Public Records Act, with either actually complaints can be filed. There are some exceptions to the general rule of disclosure around public records that are kind of spelled out in the statute. They seem to fall into two different categories. One category is really focused on individuals' right to privacy with respect to students or personnel. And the other one has to do with the efficient functioning of government. So maintaining confidentiality of investigative records, records related to pending litigation, or sometimes preliminary notes or memos that might be maintained in the ordinary course of business. So these are specific exemptions that are in the statute. There can be a lot of cases about it. This is, again, the type of area you would want to consult with legal counsel. And to make records available means they can be inspected at the site, the agency, during its regular office hours, free of charge. or else, if there are requests for duplication or compiling of records is made, then there's a possibility of, making a reasonable charge for the time and the duplication costs. So again, to revisit, because we know it can seem burdensome to comply. Really, why are open meetings and public records disclosures? Why is it so important to provide that level of transparency? It really is, again, that charter schools are conducting the people's business of educating our children. And so that business must be conducted in the public. So said in another way by a parent that we work with, charter schools should have the same transparency and accountability as traditional public schools. The families want the right to be involved in all aspects of our children's education, including the programming and budgeting. And this came up in the context of Public Advocates was looking into charter schools under LCFF and the LCAP, which is a major planning and budget and education planning and spending document. But that, again, is a good example of, the kind of decision that's going to have big impact on the educational program of the school, and really thinking about what opportunities are being provided as the board is meeting, to approve or to look at that document. Are there opportunities being provided to your stakeholders, to your parents and students? Are you providing notice of that through the meetings that you're having, and giving access to that? And I realize that I ran through this, but again, the public under public records has the right to inspect the records during normal working hours, request a copy of records. If the immediate disclosure is not possible, the agency must make the records available within a reasonable time period, and there can be a reasonable charge for compiling and copying records. There is a specific timeline to respond and make a determination about whether a record exists within 10 days. So again, this is an important area for staff to get training on. And I'd forgot. And so I think I ran through these exemptions. Again, generally they're to protect individual privacy rights or kind of efficient functioning of government. And in each case, there really is kind of a balancing test to be had to weigh the public interest in disclosure against whatever interest there is against disclosure. And there is a strong interest in really conducting the public's business out in the open and in public. So really wanting to be careful about not overusing these exemptions. Then the last part of kind of area of SB 126 has to do with conflicts of interest. And this requires charter schools to comply with the same laws that apply to school districts and other public entities, prohibiting conflicts of interest in public contracts, and also requiring public officials to perform their duties in an impartial manner. And that means free from bias towards their financial interests or the interests of their supporters. So again, going back to what I said in the beginning, in terms of the intent is to ensure that charter schools are being good stewards of the public funds that they control in service of their students, really wanting to make sure that no public officials are kind of benefiting from taxpayer dollars, accruing their own financial benefit to themselves. This also ensures charter authorizers would have access to vendor contracts and finances, loans of the charter operator. So under these laws, charter school boards do have to adopt a conflict of interest policy, and they do have to have their board members complete financial disclosure forms. One exception that's built into this law to the general conflict of interest rules is that a charter school employee may still serve on the governing body, but they have to abstain from attempting to influence matters uniquely affecting their employment. So you'd have to draw a wall around that person when it came to any decisions that would affect their employment, their financial interest. Why prohibit conflicts of interest? As I said, charter schools receive approximately $3.4 billion in public funds, and they serve 10% of our students. And over time, there have been instances of financial mismanagement or fraud. For example, in this June 2017 extraordinary audit by FCMAT, the Financial Crisis Management Organization for the state, their analysis concluded that the charter school operator's management may have failed to disclose numerous conflict of interest relationships and diverted, commingled, and misappropriated public funds. And in this case, there were allegations of tens of millions of dollars that might have been, of taxpayer funds that might have been diverted to individuals associated with the charter management. So again, this really goes towards ensuring that charter schools, charter school leadership are acting as good stewards of the public funds they're receiving in service of their students. So there's some other resources, the text of SB 126, we'll share out these slides, and here's some links. It's actually not a very long law because it really references a lot of other laws, including the Brown Act and the Public Records Act. So here are some guides on that. And also the Attorney General opinion that was issued in December gives a pretty good overview of these different areas of the law. And now I'll pass it back to Ruth.
Great.
To continue with our presentation.
Great. Thank you so much, Angelica, for setting that context and giving that info. And as we share, we'll be moving to implementation of AB 1360, and Oscar Lopez from East Bay Community Law Center will be starting around the implementation of the due process protections in that law. So thank you, and go ahead, Oscar.
Thank you, Ruth. Can everyone hear me?
Yes, you're good, Oscar.
Thank you. Hey, everyone. So as Ruth said, my name is Oscar Lopez. I'm an attorney with the East Bay Community Law Center in Berkeley, and we represent students in all of Alameda County. So I want to talk about AB 1360. AB 1360 took effect on January 1st, 2018, and can be found in California Education Code, section 47605B. The law does two things. It clarifies that minimal due process for school discipline does apply to charter schools, and two, it also prohibits the use of discriminatory school admissions policies. So why is this important? Years of research and numerous experts in pediatric health have conclusively established that exclusionary school discipline is harmful to not only the suspended or expelled student, but also for overall school climate. In particular, exclusionary discipline results in a higher likelihood that students will be disciplined again and will come into contact with the juvenile and criminal legal system. Students also face a lower likelihood of graduating from school and going to college. Research also indicates that schools with high rates of exclusionary discipline also have lower rates of academic achievement and school climate ratings. So what exactly is due process? Due process refers to the process that must be followed before a court or agency can take away any individual's rights. As I mentioned a few moments ago, AB 1360 describes some of the due process owed to students before they can be suspended or expelled from school. In particular, AB 1360 states that, at minimum, charter schools must adopt procedures that comply with federal and state constitutional requirements. So what are federal and state constitutional requirements? For that, we have to look at previous legal cases. In a case from 1975 called Goss versus Lopez, the United States Supreme Court established that for school discipline, due process depends on the number of days of suspension or expulsion. The Supreme Court created a distinction between suspensions of 10 days or less and suspensions of more than 10 days, including expulsions. AB 1360 reflects the decision from Goss versus Lopez. The case involved a group of students who were suspended for up to 10 days from several schools in Columbus, Ohio, for participating in student demonstrations. All of the students were suspended by their school principal without a hearing, so they filed a civil rights lawsuit against the Columbus Board of Education. The Supreme Court concluded that suspending students could seriously damage the students' standing with their fellow pupils and their teachers, as well as interfere with later opportunities for higher education and employment. As a result, the Supreme Court stated that suspending a student for up to 10 days without a hearing is a violation of a student's due process rights. The court went on to explain the minimum due process owed to students for suspensions of up to 10 days. A school district must provide oral or written notice of the charges, an explanation of the evidence that supports the charges, and an opportunity for the pupil to present their side of the story. Failure to comply with these minimal requirements can result in expungement of the suspension from student records. In 1976, 1 year after the Goss versus Lopez decision, the California legislature passed a law that guaranteed students in public schools additional safeguards. However, for purposes of today's discussion, I want to mention that none of these additional safeguards explicitly apply to charter schools. Again, for the moment, none of these additional safeguards explicitly apply to charter schools. But as you've seen, it is always possible that legislation or lawsuits can change the laws that apply to schools, including charter schools. And for that reason, among others, I would encourage all charter schools to adopt these additional safeguards in full, which can be found in California Education Code section 48900, and include limiting the grounds for suspensions, limiting suspensions to situations when other means of correction fail to bring about proper conduct, restricting the total number of days of suspension to 5 consecutive days, restricting the number of days of suspension to 20 school days per year, and providing an opportunity to appeal a suspension. As a reminder, the court made a distinction between minimal due process for suspensions of up to 10 days and more than 10 days, including expulsions. I'm now going to summarize some of the due process law for expulsions. In the Goss versus Lopez case, the Supreme Court referred to a different case from 1961 called Dixon versus Alabama State Board of Education. The case involved a group of Black students who attended an HBCU. The students went to a lunchroom in a Montgomery, Alabama courthouse and were refused service, and the police were called on them. As a result of this incident, several hundred students organized mass demonstrations. After receiving a call from the Alabama governor, the president of the HBCU told the students to behave themselves and return to their classes, and subsequently expelled them without any notice, hearing, or appeal rights. The students then filed a complaint alleging that their 14th Amendment rights were violated. In this case, the Court of Appeals concluded that the students were denied minimal due process and explained that students must receive notice and an opportunity for a hearing before they can be expelled. After this case, several other lawsuits were filed, which further defined the minimal notice and hearing requirements. In 1977, students in California filed a case against the Oxnard Union High School District called Gonzalez versus McEwen. This case also involved a series of demonstrations by students, after which the students were expelled. After reviewing the facts, a California appellate court stated that before students can be expelled, they must be given sufficient notice, which must include a statement of the specific charges against the student and a statement of the basic rights to be afforded to the student. The court also discussed minimal hearing requirements, including the right to be represented by counsel, present testimony, evidence, and witnesses, confront and cross-examine adverse witnesses, and a fair and impartial fact finder. The California Supreme Court later adopted that decision in 1982. So here's a quick summary of the minimal due process requirements for students in charter and non-charter schools. And the non-charter schools does not include private schools. I also want to note that there are additional federal laws for students with disabilities, and these laws also apply to charter schools. Specifically, before a student with a disability can be recommended for expulsion, the school must convene a manifestation determination review meeting and discuss two questions. One, was the conduct caused by, or did it have a direct and substantial relationship to, the student's disability? Or two, was the conduct a direct result of the school district's failure to implement the student's IEP? If the answer to either question is yes, the student cannot be expelled. However, as I mentioned earlier, the California legislature has established additional safeguards for students, including in expulsion cases. Once again, none of these additional safeguards explicitly apply to charter schools at the moment, although many charter schools have already adopted many of these provisions in their school discipline policies. Given the significant harm caused by expulsions and the possibility of future litigation, I would also encourage all other charter schools to adopt these additional safeguards in their discipline policies. To highlight the importance of these safeguards, I want to share a few of the continuing challenges in enforcement of disciplinary due process rights in charter schools. My team here at the East Bay Community Law Center, as well as the public counsel team and colleagues at other legal nonprofits, have faced the following challenges in our cases. Last-minute changes to hearing dates and times that impacted a family's participation in due process, failure to provide translation services, delays in release of documents related to disciplinary incidents impacting preparation for hearings, and lack of knowledge about the passage of AB 1360. And we know that these are not isolated incidents. Finally, I want to turn to one last issue that was addressed in AB 1360, which is involuntary removals. This refers to disenrollments, dismissals, transfers, or any other type of informal removal. Before a student can be involuntarily removed from a charter school, they must be given written notice at least 5 days before the removal takes effect. The notice must be in the parent's native language and must inform the parent of their right to a hearing. If the student requests a hearing, they have a right to remain enrolled at the charter school until a final decision is issued. And with that, I'll turn it over to Ruth.
Thank you, Oscar. Thank you, Mary, for your question. We have done a lot of different policy work on in-school suspension and teacher suspension issues. And so we are all quickly checking the ed code provisions with the actual prevailing cases that Oscar discussed. So let's have Victor get through his information for us to double check to be able to provide you clarification on all of the different kinds of suspension. So thank you for your question, Mary, and now I'll hand it over to Victor.
Hi, good afternoon, everyone. My name is Victor, and I work for the ACLU of Southern California. So my portion is going to be discussing what types of admissions requirements are permissible and impermissible at charter schools here in California. AB 1360, Oscar went over the kind of discipline side and due process side of the law. The other side is to clarify the rules on admissions. And so even before AP 1360 went into effect on January 1st, 2018, the general rule in California has always been that a charter school shall admit all students who wish to attend the charter school. That's a direct quote from the Charter School Act. There are only very minor exceptions, not particularly worth getting into, aside from one of which you're probably already familiar, which is if a charter school is at full enrollment, then it may hold a lottery and then keep a wait list to determine who gets in when they exceed capacity. And so what made AB 1360 necessary, given that the law was already clear? Well, we, from our collective organizations, received intakes and outreach from parents and families, making clear that many schools either didn't understand or were violating the law and implementing improper and impermissible admissions requirements. So we'll provide a few examples of intakes we received before the law went into effect. So one was requiring parents to volunteer or purchase supplies or provide donations as a condition of enrollment. That has always been illegal, and AB 1360 clarified that that is not allowed under the Charter School Act or the new provisions in the Ed Code. The second is that schools would enact policies that weren't on their face exclusionary to certain student groups, but would have the impact of excluding high need or other vulnerable student populations. So for example, we found schools where the families and students in the neighborhood were 90% people of color, but the school only enrolled 10% of people of color. So there was some barrier, whether intentional or not, to having the demographics of the neighborhood be reflected in the charter school. And the third, we found plenty of violations. Public Advocates and ACLU released a report a couple years ago assessing just charter school policies across the state. And we found over 200 violations where charter schools were enacting exclusionary admissions policies. An example, a pretty flagrant one that we found pretty frequently amongst charter schools was academic requirements. So here in Southern California, we found a school where students whose GPAs dropped below 2.0 were asked to leave, or students who were applying the GPAs under 2.0 were not enrolled because they didn't meet a minimum GPA requirement. So we passed AB 1360, other groups on the phone and a broader collection of partners. And AB 1360 makes several things clear. First, before we get into the actual, admissions requirements and preferences and examples of what's impermissible and permissible, there's three kind of main threshold issues for a school to enact any admissions requirements. First, it needs to be approved by the chartering authority at a public hearing. Second, it needs to be in compliance with both federal and state discrimination and civil rights laws and the Constitution. So that's Title VI, Title IX, and the other discrimination lawsuits in the state and federally. And then finally, as I mentioned before, the schools explicitly cannot require parents to volunteer as a condition for enrollment. Of course, a charter school can encourage parental involvement, and that can be a very good thing to build the community and make sure parents feel connected to their children's education, feel like they have input into it, but that can't be a requirement for enrollment. So specifically, these are the enumerated categories that AB 1360 prevents in terms of admissions requirements. This is a non-exhaustive list, so there are other categories of admission requirements that are not permissible as well. But these were the main ones that the various groups that supported the bill saw across the state, so we wanted to make sure that we provided these as examples enumerated in the statute. So first, it's students with disabilities. You cannot deny or prevent enrollment or discourage enrollment to students with disabilities, academically low achieving students, English learners, students impacted by exclusionary discipline or who've had prior contact with the juvenile justice system, youth experiencing homelessness, students who are economically disadvantaged as determined by eligibility for free or reduced lunch or generally, foster youth, or students based on nationality, race, ethnicity, or sexual orientation. So these were the big categories that we saw, but if a charter school excludes other types of students, it also likely would be inadmissible or improper under both AB 1360 and the General Charter School Act rule that they must admit all students. So just providing some more examples of impermissible requirements that we've seen. Minimum GPA or test scores for entry, or if a student's GPA or falls below a certain level, or if they fail a certain test, then they're pushed out of the school. Minimum English proficiency, we've seen it both in terms of requiring students to have a minimal English proficiency and also parents. Mandatory parent volunteer requirements, this can be both requiring, a minimum number of service hours per semester, can also be requirements for donations or requirements to purchase school supplies. Essays or interviews as part of the application process. This one has a little bit of nuance. It is absolutely impermissible for a school to enroll or disenroll students based on their performance of those essays or interviews, but schools can ask students or families to answer questionnaires in order to provide the proper supports for the student and to acclimate the student to the school culture. Our recommendation for best practice here is to enroll the students up front, guarantee them a spot, make them understand that their performance on the essays or interviews are not a condition to enrollment, and then gather that information on the back end once the family understands that they're enrolled. We also have seen discrimination or exclusionary practices against immigrant students or non-native English speakers in terms of not providing translated materials, or from schools asking for immigration status of children, their parents, or requiring them to provide documentation about their citizenship or passports or things like that. All of that is impermissible. And so my final point on this is to make clear that the intent is not the dispositive factor here. So it is not only policies that have the school intends to exclude students that are impermissible, but also if policies are neutral, or at least on their face are neutral, but have the impact of excluding certain students, then those are impermissible as well. And an example of that would be if schools provide really intense questionnaires. We've seen schools with 20, 30 long answer questions, and those types of questions up front discourage students, even if they don't prevent students from applying. You discourage them from applying, and then, as I mentioned earlier, it skews the student population to exclude certain student groups. And so we urge, authorizers and charter school operators and families to very carefully examine the admissions policies and practices for even potential barriers, and then to eliminate those to make sure that charter schools live up to the promise of providing education to all students in California. And so our final agenda item here is to discuss a little bit about what you all can do, and I know we have a pretty diverse group of people on the line. So I'll start with charter school authorizers. The first thing to do as a threshold matter, and I'm glad to see so many people on the call today, is to familiarize yourself with the Charter School Act, SB 126, the new law Angelica mentioned, and then AB 1360. We have helpful fact sheets and have links to some easily digestible Know Your Rights materials that we can circulate after the call. And so you should also ensure that all new charter schools that you authorize and approve understand and obviously comply with the rules, including making site visits to make sure that there are no exclusionary barriers or that the schools have the due process protections in place. You should review the school charters, handbooks, forms, websites, and all other outward-facing documents to make sure that schools are compliant, and that if you put yourself in the shoes of a family applying to the school, and make sure that it would feel comfortable and open and inclusive for you to apply. To analyze whether charter schools' demographics align with those in the neighboring schools, and if they don't, and you should check this periodically, try to investigate why and eliminate those barriers even if they're not obvious. And then finally, to spread the word and to notify your authorized schools about these laws, notify your communities about these laws, and make sure that other authorizers also are aware and are doing their due diligence when they're authorizing and approving and reviewing schools. So I'm going to turn it over to Angelica really quick.
But Victor, can you back up? I just wanted to add in there that I kind of I think you emphasized the AB 1360, the admissions and the due process angle, but also from the angle of transparency, accountability, the open meetings. That's also something now as authorizers to be thinking about, you know, when you're reviewing the website, are agendas being posted, are records of meetings being posted, recordings of meetings being posted, and that's another tip, you know, dropping in on a board visit to see that the meetings are being conducted according to Brown Act and openly could be another, you know, focus of site visits.
Great. And I'm going to turn it over to you again, Angelica, to talk about what charter school operators can do.
Yeah, so again, similarly, I think it really is familiarizing yourself with the Charter School Act, and SB 126 and AB 1360 really are amendments to that act. Sorry, I'm looking at the wrong thing. So you can train, I think really important is to train and support your board members and staff to now understand these new legal requirements, especially for those schools who maybe had not been, if you had not been familiar, for example, with Public Records Act or how the Brown Act works around meetings, it could be a kind of a significant change to your practice. So reviewing meeting procedures to ensure that you really are complying with open meetings laws, that you're providing timely notice of your agendas and opportunity for public comment, particularly if you have a board who maybe might have been meeting in a more informal manner, to really take a look at that practice and make sure that you're not, you know, engaging in kind of informal meetings of a majority of the board, a quorum of the board, with, you know, that actually are supposed to be noticed in public meetings. Setting up systems to timely respond to records requests. And one practice tip that I heard from Oscar is just to really make sure if you are responding to requests that you are also being mindful of the privacy rights, so that not wanting, you know, as somebody who might request information, I don't want to receive private student information in records that are disclosed to me. So having the systems in place to really do that review, to redact any sensitive information. Posting your financial school plan documents on your website for public access, adopting conflict of interest policies, and also ensuring your board members complete those financial disclosure forms. So these just relate to what, you know, kind of SB 126, and some of these things perhaps many charter schools were already doing, but really important to do a review and make sure that folks understand the requirements here. And then, can you go forward, Victor?
Yeah, it's at the next slide already.
Okay. And then also with respect to the admissions and due process requirements, really reviewing your handbooks, your forms, your websites, making sure that those are complying with the law, that they're not setting out any barriers to any student groups. And including the most inclusive and welcoming language possible on your materials and forms, really being thoughtful about translation and inclusion of non-native English speakers, especially if that is, you know, the community that you're serving or the location that you're in. And then there are both, as Oscar said, there are the minimal due process protections that are required, but actually thinking about providing, you know, those greater than what AB 1360 requires, and joining those best practice schools that are following the procedures in the education code to really make sure that we're, you know, not excluding children from the education space. And finally, Victor, did you want to speak to students and families?
Sure. And this actually is responsive to a question I see in the chat by Karen about accountability and an avenue for parents to complain or challenge a particular policy if charters are not complying. So here's our advice for students and families. First, just like everybody else in the system, you should definitely familiarize yourself with the Charter School Act, SB 126 and AB 1360 and other laws. And again, we will circulate some very easily digestible materials, providing kind of a nuts and bolts account of what these laws all mean and your rights under them. You should also exercise your right to engage in local charter board and open meetings, making public comment. As Angelica mentioned, that is your right under the Brown Act. And then to review documents regarding your charter school. And you can review those documents either on their websites, and if they aren't on the websites, then under the PRA rule, you can now submit a Public Records Act request for those documents. You should also apply for a charter school, and if you believe that it has a discriminatory or exclusionary policy, you can file a complaint. First, you can file that complaint with the principal, and then if the principal denies it, you can file it to the charter school board, and then appeal that to the authorizer as well. You can submit that as a UCP complaint, Uniform Complaint Procedure complaint. That is a general kind of administrative complaint process available to all stakeholders if you're challenging something at a charter school or traditional public school. And then the link there, which we can also circulate, is a sample form that already has some pre-populated fields that address some of these issues in AB 1360. And then, again, if you're facing a suspension or expulsion, or if a school asks for you to leave informally, then for any reason, you should ask for a hearing to challenge it. You should review all of the various due process procedures that Oscar mentioned. AB 1360 could be like the due process requirements that Oscar mentioned could be what applies, or the charter school could have opted to provide greater due process protections, that they have the discretion to do that. So you should definitely look at the school charter. You should ask the administrator of the schools what your rights are, and then make sure you follow those procedures and challenge the suspension or expulsion accordingly.
I just to go to the question, I started to type to Karen's question about, what is the accountability system to ensure there's compliance? Has anything changed after AB 1360 in addition to just the complaint? So as Victor said, AB 1360 did clarify that the uniform complaint procedure does apply to these issues around admissions. And then I know of at least one authorizer, but I think all authorizers should really be taking, in their duties as an authorizer, should be making sure that the charters that they are overseeing are in compliance with these rules. So I know at least one authorizer that has undertaken a review of kind of the admissions materials, making sure there's no parent volunteer requirements or other kinds of barriers.
Great. So Ruth, let me pass it back to you, and then maybe we can answer questions at the end.
Great. Okay. So thank you all. This is Ruth Cusick again from Public Counsel. And what I'd like us to do now, because we've had various questions coming through in the chat box, so if you are thinking about questions, please feel free to type those in. But I'm just going to, go through them and have us and also, as you can see, what's up now is something that you can do. So our presenters have shared. So in addition to questions, feel free to share, some of the next steps you're thinking about. So it can be organic around our participants sharing next steps and beginning to go through the questions. So I'm just going to review some that we already had, which is a question from Mary about the public getting an item on the agenda with which Angelica typed in, but will you just share again, Angelica, so that everyone can hear your response? And since we are recording this and we will post this to the Fixed School Discipline website, so if you have any other colleagues or partners who you want to review this, we will send a notification that will have the full webinar and you can review all of the slides that way, just so you all know. So Angelica, will you share about public having access and to agenda and comment?
Sure, yeah. So this is a reflection of the newness, I guess, of the law, in that I do Brown Act trainings, but I've only been doing them for traditional school board members. So generally when I talk about open meetings, I talk about this public right to access and that the public has a right to put items on the agenda. I realized in looking back that that is something in a specific provision in the Education Code that applies to school districts, but is not a part of the Brown Act. So actually I don't think that would apply in this instance because of the Brown Act. However, a member of the public has the right to comment, give public comment at a board meeting under the Brown Act on agendized items as well as non-agendized items. So there should be an opportunity to raise items even in that part of the agenda, the non-agenda portion, so long as it's something that's within the charter school board's purview. So I wanted to make that clear. And I also did really want to also share a couple things that have come into us is that with parents who have been trying to exercise their rights, we have had some parents who have experienced being excluded from the meeting by coming in or expressing criticism. And again, you know, that is not allowed. It is the public's right to express criticism in their comment. And so wouldn't want to see that practice happening more broadly.
Great. Thank you, Angelica, for that clarification. And so our next question was from Sandy Park, who asked, can a specific type of program, like a music-focused program, require students to have a certain music proficiency? Or if it is a middle school dual enrollment program, can there be any proficiency requirements? So we'll have Victor answer that question about specialized charter programs.
Sure. Yeah, thanks for the question. The answer is, I apologize for the vagueness, it depends. Really, it depends on how the school is operating that music plan. I'll give a couple of examples of ways that are permissible and impermissible. What I would argue is impermissible is if the school is requiring students to have already adopted a certain level of proficiency to be enrolled at the school at all. For instance, if the school requires only excellent piano players to enroll, I would argue that that excludes pupils who are economically disadvantaged and potentially other types of students as well, because they will have less access to piano classes, the equipment, the training that higher income students would have. And I think it would be a difficult question for a court to assess, and I think it would require an analysis of the school's demographics and whether there are any differences in terms of the students in the local geographical area and who the school is enrolling. And I'll tell you, give an example of what is very clearly permissible and what we would recommend as a best practice for a school that does want to focus on, for example, the performing arts. So what a best practice would be to enroll all students who wish to attend and provide all of the arts and music and theater support that the school intends to. But if the school wants to have a specialized program for particularly advanced students, then have that within the school after the enrollment process is complete. So you can enroll all the students and then have an internal kind of a varsity or like an advanced assessment process where only the best students would then have access to an accelerated program. But any student who would want to attend could be enrolled and could enjoy all the different resources that the school would offer. So unfortunately, it's kind of a nuanced answer, but different schools are going to operate in different ways. And I think it is really, I'm glad you're thinking about it, because it is really important for the community to assess how these programs operate and then to try to intervene when they really are working to exclude students. The second question about middle school dual enrollment program, I assume it means referring to like a dual language enrollment program. I mean, dual language enrollment programs are permissible. It's actually quite a recent law. Now the state permits bilingual education. But again, we would argue that those should be open to all students who wish to attend, and there should be no language requirement, beginning proficiency requirement to enroll students.
Great. Thank you, Victor. This is Ruth again, so I'm going to keep us going on the questions. we, during Oscar's information about due process, Mary asked if these due process requirements apply to in-school suspension. So I'm gonna have Oscar share what he had entered in for our attendees in the chat box so that everyone can make sure to have that information. Go ahead, Oscar.
Thanks, Ruth. So, Mary, if you read 47605, it does not make a distinction between out-of-school suspensions and in-school suspensions. And doing a little bit of statutory construction in different parts of the Ed Code, there's a section that says suspensions, including supervised suspensions, shall be imposed only when other means of correction fail to bring about proper conduct. So the way I'm reading that is that supervised suspensions, and if you read the description of that, it sounds like a lot like in-school suspensions, are not considered other means of correction. And therefore, even for in-school suspensions, due process does apply.
Great. Thank you, Oscar, and thank you to everyone who've already entered questions. We're just making our way through them. So Karen asked if charters weren't complying before AB 1360 with fair admission rules, what will be happening differently now to ensure compliance? And we have folks asking a few different compliance and enforcement questions. So Victor, I don't know if you want to add anything around, you know, monitoring fair admissions since implementation, or we can all answer around more broadly, you know, enforcement and compliance, but want to see, Victor, if you'd like to share anything first on the admissions front.
Sure, yeah, I can kick it off. I mean, I think the bottom line is that compliance is under the purview of the authorizer and potentially the state. But the first line of defense is the authorizer, and that's where complaints can and should go. I'll just provide a recent example we encountered here at the ACLU. We received a complaint from a parent whose child was not allowed to attend the charter school, essentially submitted an application and was denied. The reason given was that the school required all students to have passed, quote unquote, passed the previous grade and to have gotten a C or above in every class. And really that, I mean, that is a fairly clear violation of both the old law and AB 1360, prohibiting enrollment for academically low achieving students. And what that meant was if a student had ever got below a C in a class, that student would completely be barred from enrolling in the school forever. So that rule violated AB 1360. We encouraged the student to submit a complaint letter. She submitted it under the template that we linked to earlier. The school stuck to its guns and said that the rejection was permissible, even under the new law. We then appealed that. We sent a letter to the authorizing entity. The authorizing entity investigated and found, I think correctly, that that was an impermissible policy that the school was holding, and the authorizing entity then required the school to admit the student. So I think that is one nice example of an authorizer understanding the rules and then intervening to enforce the student's rights and to do the right thing. And so I'll pass it back to the others if they have other examples, but I think that's a good example of kind of the accountability mechanisms that are in place. The only thing I'll add is some authorizers are better than others for a variety of reasons. Some are more sophisticated, some have more resources. You know, if you look at a district like LAUSD that has an entire department devoted to charter regulations, they're going to really understand the law and make sure their schools are in compliance. And if you're in a much smaller district or in a district or rural area without a lot of resources, it is much harder for them. So parents can and other community members definitely should play a role in making sure that the charter authorizing entities are well aware of the rules and then hopefully can have the resources to step in when they're violated. So I'll pass it back to the others now.
Great, thank you, Victor. And this is Ruth. I just want to reinforce, as Victor shared in his main slides and Angelica reinforced in the chat box, that AB 1360 did make clear that the UCP, the Uniform Complaint Process, should be the process of complaint, so that families have that avenue available to them if they are documenting concerns, just like the case example that Victor just shared, and more broadly around compliance and enforcement. That we have a question from Lee around whether the legislation spells out that responsibility for authorizers on enforcement and what are the consequences. So, I mean, I would share additionally for the public counsel team, like Victor's example, that we believe community monitoring and accountability is very important, especially given that these are recent changes in laws. So our team has a broad practice around Public Records Act requests that support community monitoring efforts in districts and around charter school issues, so that mechanism is important, but want to be clear that these laws didn't change the authorizing structure. So I don't know if any of our other presenters want to add to that, but there are pretty limited and strict avenues around when authorizers shift and change jurisdiction about whether schools are open or closed, whether charter schools are open or closed. So Angelica or Oscar, would you like to add to that?
Go ahead, Oscar.
Yeah, just the one thing to be mindful of for authorizers is when you are providing oversight, it's careful to also be mindful of student privacy rights. So you wouldn't want to put any students' student information or any confidential settlement agreements that they've reached in jeopardy, right? So, and I bring this up because I have worked on cases recently where the authorizer requested a release of a confidential settlement agreement, which I still consider a breach of contract, when there were other alternatives that would have been just as sufficient to satisfy the oversight responsibilities, right? So I just want to make sure that when if you are an authorizer and you are providing oversight, to please be mindful of the implications of your oversight on student privacy.
Okay, and what I wanted to add just on the question, so in terms of the statutes themselves, I'm not sure that it doesn't really articulate an enforcement scheme beyond the UCP for AB 1360, although, we're all lawyers on this, so we are always aware that litigation can be an option. I know with respect to Public Records Act requests and Brown Act on SB 126 that there is case law in that area, and that it could a failure to be responsive, I guess, to concerns could lead to accountability in that way. I always take the expectation that an authorizer, part of the authorizer's role in whether it's an approval or in renewal, is also to ensure that they should not be approving petitions that are on their face because of the admissions requirements or are discriminating or violating the law, and that even though there are kind of very articulated bases for denial or approval in those decisions, that an authorizer should not be condoning practices that are illegal in violation of the law. A charter petition should be complying with the law. And at the same time, I think overall, in terms of resources and capacity, it really is, as Ruth said, really important for community members or students, families, or staff to kind of raise questions where they have it, to actually be able to seek to exercise their rights. And because I think some of the challenges are, with there being so many so many schools out there, it's really hard to know what's going on unless people are kind of lifting that up. And lifting that up, and not only just, I think, to the school and the authorizer, but, you know, to the state too, which ultimately is going to be making recommendations around the charter school accountability and oversight scheme.
Great. Thank you so much for that, Angelica. Now we're going to do a few other questions that have come in. And so one is around, Karen asks, what is the state doing to communicate the content of these laws to authorizers? So to our knowledge, so just to be clear, it's to our knowledge. We can't for sure verify, but to our knowledge, there isn't any specific outreach strategy by the state. You'll see here up now on your screen and available on the ACLU's website that our teams together put together a fact sheet around the requirements so that this can be widely disseminated and shared both with authorizers, with charter school operators, and it really is a community focused work for those who are charter management organizations or who do work in county offices of education, to think about ways that they can proactively get this material out. Any presenter want to add anything to that before our next question?
Well, because district school boards are often authorizers, or probably most of the authorizers in the state. California School Boards Association also released a report last year, I think, that really focused on the role of school districts as authorizers and the role of school board members. And I understand that I think they're doing briefing on that for their members. So I think for those school boards or school board members who are part of the California School Board Association, there might be resources there. But with the state itself, I think it would be great to see the state being more kind of proactive.
Great, thank you, Angelica. So our next question from Annabelle is where community members can go to figure out when a charter school's charter is up for review before the authorizer. So my best bet would be using the Public Records Act request to make those requests to the authorizer for the actual charter, which will give information on the length of authorization, because for those of us who have done advocacy at the school board level, the notice on the agenda is going to only happen with that specific timeline to share the agenda notice, but that really will be in terms of the legal agreement between the charter authorizer and operator around the length of the charter authorization and when it will be coming up for renewal and review before that renewal. Anyone else want to add anything around that question for gathering information?
Just from a practice standpoint, or I guess a practical standpoint, two thoughts. One is whenever possible, I try to obtain information without having to do a formal Public Records Act request. So where it's possible, and you might have a relationship already with that office, they probably already know, the authorizer office knows what the schedule is of what charters are coming up or not. If it's a specific charter that you're interested in, two, you may be able to find out also from the charter. I remember when we were doing some work for our report, I was surprised, and I'm hoping that actually often the charters are not, and the charter petitions are not posted up or easy to find, and it is something that you have to request. I think it would be a best practice and proper to, for schools to, post up their charters as really important governing documents, especially after the passage of SB 126, and would encourage charter schools to be doing that.
This is Victor. I'll just provide one other, at least local to me, example. a lot of the larger districts in Southern California, when the authorizing entity is reviewing charters, they put it up on their websites and put it up on the agendas for their open board meetings, and so you can get a sense of, with a list of which schools are up for renewal each year through just the district agendas.
Great, thank you for that question. And Angelica, thank you for that really thoughtful practice idea that as charter school boards are coming into compliance with SB 126, that this access to the charter would be a great best practice on transparency and giving everyone in their school and organizational community that information. So we're happy to take a few more questions if anyone has questions. We did answer the enforcement and compliance questions together in a group. So if you didn't feel that your question got answered, feel free to type in any clarifying question. And just want to share again that Angelica shared that public advocates will be creating a SB 126 fact sheet that has these core, bullet points requirements that she shared on the webinar today, similar to the AB 1360 fact sheet, and that those should be widely shared, and that for this training, if you want to share this with anyone else, we will be posting this training to our website, and we'll send you all a notification when it's posted so that you can feel free to review again or to share with other colleagues who are not able to attend. Okay, well, now that folks have had a little time to think about whether they had any other questions, and we don't see any new questions in the chat box, I am going to thank you so much for your participation and engagement today, all your thoughtful questions, and for your flexibility with us all as we do this work across many different cities to get on this training together. So thank you again.